Howdy, this is Dr. Stacy Lyle. This is a quick review of Module 5, or Assignment 5, about the transfer of title of land, looking at this peculiar court cases that took place trying to determine land ownership. I thought a quick video might be helpful. I'm going to drop down quickly just to the information and look at it. Basically, this working sketch is all we really need. It is somewhat to scale, showing the different information between the different landowners. The first thing that we should know is the dignity of calls. The dignity of calls state that we must go with the intent of the document. That's not what was in their head, that's what they put on the document itself. Next, after that, we follow the footsteps of the original surveyor, the points set and found and called for hold over the measurements that we find. When it comes to the measurements that we find and the items that we find, natural monuments are over artificial. And natural monuments are typically rivers or streams or creeks, or could be giant rocks, not rocks human set, nor could it be trees. Trees occur naturally, but we call to them artificially. We also must look at junior senior rights, who has been first, and then who's second, who's third, and so forth and so on. In this scenario, we have the fender, which is the most senior, and this is evident when we go down and read the documents below. It has to do specifically when the date it was surveyed, not necessarily the patent, so we're looking at the date, but we can see that 1903, and then up here 1943, and then we have 1927, and then we have an easement in 44, and then the county minutes in 63, and then the highway department in 66. Going back up to the drawing though, we see that what happens in the scenario as it's drawn here for the first working sketch, it appears that we have the distances in varas, 2800 varas, 1300 varas by 28 by 13. We go out and look at that. We actually find longer distances in that scenario. And then we have the different information that's here. The big one that's the tricky part here in the corn survey is that they call for the fender corner, but they actually fall short in getting the fender corner. Now, a lot of times there's also this testimony that we have here. That's called parole evidence. It typically falls to the lowest, and we don't use that. Also, the area of the tracks fall the lowest. But you'll find that all these measurements seem to be longer. One of the problems is they could have used the wrong measuring of a vara. Instead of 33 1/3 inches, they could have used 36 inches or a yard in their measurements. But the fender portion works well. Corn would not fall short, and there would be a gap here. Klaus, who did call for that same corner, there is this portion here that goes there. Now when we come to this corner, it comes to a point at a stream where a tree varies from here to there, so we want to look at that. And then we're going down this line and we're passing these calls. These are passing calls, not holding calls. We really are thinking of the line from his point to that point. We use the passing calls as ways to establish this line if nothing else exists, but we do not hold those. We hold from this point to that point. So let's just jump to the questions and see how we do. And first question says, in determining the acreage of the corn, you would hold the east line found between 2 and 5 and 2. And a lot of people would say no, they would have held between points 2 and 12, which would have been incorrect. That would have been the correct answer in that scenario. And then the other points or questions are there to just distract you. Okay? And determine the acreage of the James Fender, you would hold the east line at 7 to 12. You would hold the east line from 7 to 5. No, because that's the point from the track to the south. You'd place the east line at 2800 varas. No, again, we use what is what their intent. Their intent was to set those points. That's what they did, not their measurements. You would set a point at the southwest corner 3,611 feet from the point of beginning. The point of beginning has no more value than any other point in a survey. We talked about that. Set a point at the northwest 100 varas west of that. That's not correct. I would hold A again here. In determining the acreage of the class survey, you would hold a straight line between 4 and 9 without passing through 6 and 8. That would be correct. All right, construct a line through this. That would not be correct because those were passing call. Place the west line between the iron pins found at 5 and 2. Again, 5 is not our corner. We're going to the corner of 12. All right. Hold the west line at a point 30 feet from 12 and 2. Now that's us giving away the county road. Although we dedicated the county road, we still own vested interest in the land underneath. So for example, if there were minerals, we would want to claim those. So we'd never want to give that up. We'd hold the west line through 12 and 2, but deducting the acreage dedicated to the county road. Again, we never want to do that because we don't want to let go of our value of what we own for that. The land acquired by the Highway Department Corn Survey would best described as, well, it is going to make a triangulation piece, if you will, because what we're going to look at is that the road is fully set inside the class survey. When we widen it, it will go over here and extend on up, and then it will go over here and extend on up. And we will find that it will eventually cross this line. This might not be perfectly to scale, so it might cross this line right here, and it will leave a small triangular piece here that comes out of the corn, and then a triangular piece here that is probably still owned by the state. So we go back down to our questions, and it says, you know, we would read a triangular piece 70 feet at one end, 0 at the other, or we'd have to calculate what that is, all right? And we would go through there and be able to answer that question from there. Next one, it says, to place the track required in the fender survey. Again, this is with us extending the track on up. We'd have to calculate what that is, but it would be something holding that 7 point, not the 5 point, so we know that that answer is not right. And I don't think it goes through the center line. It is going to be some feet east of the point number 7 because it is wider, and not sure what that is, but we need to investigate that. In the situation JJ, your determination of the location of the southwest corner of the corn survey is based on, now we go back up to the southwest corner, and this is the odd pieces, is where it comes to a point which is at a creek, but it doesn't go with the creek, so we're not held by that. If the creek was to move and come into our property, we would not go along that creek boundary right there, because it's at the creek. If we said with the creek, and again, key words help us in building our land GIS. And then it says that there's a walnut tree. It's not saying that we go to the walnut tree. It's 18 varas south, so it's not the vara tree. It would be a point that we'd probably reconstruct, but let's look at what they want us to do here. It says that the JJ, determine the southwest corner of the corn survey is based on the boundary of the tract tied to a stream moves with the stream. Well, that's true, but we didn't go with the stream, so that's not us. The call for directions west and south are intersected. That could be the best way to do it, right? The best evidence of the corner as located by the original surveyor. Okay, that's following the foots of the surveyor, right? But there might not be anything there. A west line run from the record of the vara, and I would not hold a distance. We typically hold bearings over distances. A corner is located given area, so area is the least. Again, in the measurement category, bearings, distances, errors. That is the dignity of calls that we have in the state of Texas. In other states, you might have distance over direction, but area is always the least. Oddly enough, it is what we based all of our finances on. All right, okay, so up here, kind of going between the direction here and the evidence of the corner as located by the original surveyor. I would take a chance on those two and use my two chances to see which one I got right. In JJ and considered the fender's pointer, the owner could clear out what might be a possible cloud of title to a larger area. Now that's saying that you have a larger set of area potentially that is what you were called for in your original deed from the state of Texas. And what you would need to do is get a deed of acquittance where they quit that deed and you get it. It's not a vacancy because you found the four corners as the four corners were called for, but there's just extra acreage. And again, that was called a deed of acquittance where the land office quits that. And that could be A right here. You can file a suit for a quiet title. This is not a quiet title where being used over a long period of time that you have acquired it through adverse possession. You're not going to do that. There's no trespass to try title. Your suit doesn't trespass on somebody else's land. It's just land of the other. And then we have the vacancy at the general land office and the vacancy at the county surveyor's office. We don't have a vacancy in the fender tract, so we're not going to really go for that in there. Corn could go after that vacancy and file for it, and they would want to go to the county surveyor office before they go to the general land office, by the way. So in the corn survey, if the chooser chooses to pursue, the first step would be, okay, so for them, they also could have excess acreage. We'll have to look at that. But again, they would need to file a good faith claim, but their good faith claim would need to go to the county surveyor first, then the general office next. So I'm going to go with E here, but I could go with D again. I'll use my two tries, but I'm going to say E over D. In situation JJ, you determine the location of the east side of the class survey on, so this is the east side of the class survey, and that's going up this road here, all right, where we have this rusted steel pipe that we think is the corner going up to 12, which is the post that was set to replace the one for fender, which we were calling as a common corner. All right, so where do we think that line sits? All right, let's go back here. In the situation in terms of the class survey, all passing cars are controlling. Oh, this is the east line. I'm sorry, that's the passing call. All passing calls are no, they're not. Passing calls only control lines of uncertainty. That is true. Natural monuments always control over artificial, but we didn't have anything natural here. We called for trees, but trees are not naturally occurring as boundaries. They are called artificially. The record area is the most controlling. Never. The east line should be made parallel to the west line. That's just crazy. So passing calls only control of uncertainty. So that's an easy one there. All right, so the next one, when you report to their clients, you might say how many have acreages, how many might have that. I'll let you look through that. The decision by the county clerk to recognize prescriptive easement or prescriptive roadway and begin maintenance created an unwritten conveyance. I would agree with that. Which of the following most closely describe the circumstance? The county now owns the road by adverse possession and limited title. No, counties and states typically do not take adverse against the public. That would be intimate domain, all right? The limitation of title saying that my title has reached its limitation, not true. I would always own that land. They might have the use of it, but my title, meaning the ownership, would never go away. It would maybe could ripen into a prescriptive easement, but never ripen into a title. That has to be adjudicated through the court of law. Each of the adjacent owners hold fee title to the center line of the road. That's not true. It's totally inside the class survey. The county accepted an unwritten conveyance and class has fee title. That is correct. The public has no right to the road because it's privately owned. No, they adopted it and voted it in the county hearing, so I think it is there. The county accepted a statutory dedication. That means that it was done through a law, not a hearing. That is precedence, not statutory. And statutory is not the case. Statutory dedication would be if I designed a subdivision and then maybe in the part of giving in my plans for a subdivision in the new, Reveille subdivision, the center line of the roads, you dedicate that to the public. There's a statutory process for that. and it's not necessarily that you have to have a hearing to do that, and the county can just accept it through the county engineer's office. All right, when it goes through the areas bounded with these surveys, which of the following does not have fee title to area to the right-of-way for cover? Does not have fee title. Okay, so the current owner of the James Fender, all right, does he have the right into the existing bounded by the Fender? Which of the following does not have fee title to the area of the new? No, there will be some that will go into Fender. The public school lands, they will, because again, there's that vacancy tract. That's what we consider. The vacancy is owned by the public school lands. When Texas was running out of land, they gave all remaining lands to help support schools to Public School Fund Trust. All right, so that is the true for the county in these tracts that are located. Yeah, they really don't have fee title to this. We dedicated it so they have a right of way, but not fee title. So I'm going to go with that. The current owner of the class and the current owner of the corn, or vice versa, I should say. That is correct. They do have fee title to this. In the situation JJ, as the location of the southeast corner of the James Fender is the most correctly based on. So now we're talking about the James Fender southeast corner, where the 4x4 post was found, where they were said it replaced what used to be there. Okay, we're not going to say that the area is the one. Perpetuation of original monuments by parole evidence. That's true. It's where they said, hey, this is where my dad replaced what used to be there, and I think that's the case. The evidence of the pipe, that's if you were using 5, that's not the right answer. The record distance of the south line, the limitation of long occupation. So that would be adverse possession, that's not right, and the distances we see are larger, so that's not quite correct. Okay, so that was a quick video to try to help you. I hope it helped out. Good luck.